Good afternoon, everyone. Good afternoon. My name is Bob Siegel. I am president of a company called PrivacyRef. We are a privacy consulting company. We do assessments, we do training, we do consulting. We'll do your floors and windows if you want. Anything to keep your information private. We're here today to talk about GDPR, the General Data Protection Regulation that went into effect in Europe just a week or so ago. Just a little bit about me so you know where I'm coming from. Prior to founding PrivacyRef, I ran the global privacy program for Staples, that little stationery store down the corner. We were in 66 business units across 28 countries around the world. Since then, I founded PrivacyRef. We're in all sorts of industries, working with companies that are multinational in many cases. I'm recognized by the International Association of Privacy Professionals as a Fellow of Information Privacy, holding 6 of their 7 certifications. And I teach on their behalf, having taught 5,000 of the 45,000 registered privacy professionals in the world. A little bit about you. How many of you are familiar with GDPR? How many want to be familiar with GDPR? How many of your companies are GDPR ready? Okay, that's about the same response you'll get out in Europe as well. Most companies are not GDPR ready. So what we're going to do today, we're going to start with the basics. We're going to talk about what is GDPR, talk about why you should care, right? Because otherwise, why listen to me? Then talk about security in GDPR and differentiate a little bit about privacy and security. We're on the same side, believe it or not. And then we'll talk about some of the other requirements in GDPR, which security does have an impact on, and then some suggested next steps. Okay? So let's get started. GDPR is a general data protection regulation that came into effect on May 28th in the European Union. What it did is replace what was previously known as the European Data Privacy Directive. The Privacy Directive was founded back in 1995, and it was a framework that told the member states, plus the members of the European Economic Community, to put laws in place to meet that framework. That became a problem. Because if you have 33 different sovereign governments interpreting the same framework, there are going to be differences. Differences on how things are going to be investigated, how the law is interpreted itself, how things are funded, how investigations are done. So it became very confusing for business. In fact, it got so confusing that there's one member state that has a definition of a special category of data, sort of sensitive information, that includes marital status. Don't ask me why, but in Finland, marital status is considered sensitive data. Okay. So what GDPR does is it harmonizes all those 33 laws and makes it a pan-European law. Now, this is not the only law involved with privacy. There's the e-privacy directive that's in place today. So while GDPR talks about a legal basis for processing and how consent is defined, the e-privacy directive talks about what you have to do for direct marketing and placing cookies, for example. Okay. So I have not changed my privacy policy. Don't expect an email from me, by the way. I'm sure you've gotten a few by now. Also, member states have their own laws. Things about labor laws, for example, or investigations you may do onto different devices. That's done at the member state level, so it's supplement GDPR. So GDPR is a low watermark. Think of it like that. Okay. The bottom line is that GDPR is here not to stop business, though some people will think it is, because it takes a lot to comply with. But it's there to make sure that business can be enhanced while continuing to protect the personal information of European residents. Now notice I didn't say European citizens. Okay. GDPR applies to people who are doing things in Europe. So if I have a French citizen who's buying a product on the internet back here in the US, that person is covered by GDPR if they're doing it from France. That same person comes to the US, he goes down to Disney World in Florida, buys his Mickey ears, he is not covered by GDPR. On the other hand, I'm from Florida, so I go to Disney World a lot. My wife likes it. I go and I buy my Mickey ears at Disney World. I'm not covered by GDPR. I go to Euro Disney in Paris. I am. It has to do with where the transaction takes place. Make sense? Okay. Why should you care? The scopes have changed. Under the directive, up until the 25th, you had to have a physical presence and or data processing equipment in Europe, aside from telecommunications equipment. That's all changed. So there's a new territorial scope, there's a material scope, which we'll talk about as well. And then let's talk about what we're trying to protect, personal information. Because that definition is much broader than we here would expect in the United States. And then, of course, there's enforcement, the fines and sanctions. So first, the territorial scope takes the easy way out. A European establishment that is processing personal information. Makes sense. You're in Europe, it has to apply. The one that's changed is that GDPR applies to processing by a non-European establishment where you're offering goods and services to EU residents, or you're doing monitoring of EU residents. Now think about that for a minute. Let's take a typical retailer here that may be doing multinational business, something that's in the United States. 1-800-Flowers is based in Carle Place, New York. They only have processing occurring in the United States. Nothing in the cloud that's in Europe, no facilities that are in Europe. They do have suppliers, florists that do deliver in Europe for them, but that's it. Prior to GDPR, prior to May 25th, they did not have to comply with European law. But because they are offering goods and services to EU residents, now they have to comply with GDPR, with European law. We've now put a tremendous number of businesses that don't yet realize it under scope for European data protections of personal information. Okay. Did you guys realize that? That you might have had that problem coming your way? Okay. Also, if you're processing by a non-European establishment in a place where member law applies, think about the European Economic Community. That's that part of it as well. That's the territorial scope. Now, what types of data does it apply to? This is directly out of the GDPR. It applies to processing of personal data wholly or partly by automated means. So anything being done by computers, right off the bat's included. And to the processing of other than by automated means of personal data which form part of a filing system or intended to form part of a filing system. They don't define what a filing system is. But I submit to you, here's 3 examples. A server, that's a filing system, right? Stack of file folders going into some set of file cabinets. That's a filing system being processed by non-automated means. You guys know what that is on the left? Thank you. I don't feel so old anymore. I gave this talk once, and my 30-year-old son was there, and he said, "Dad, what's a Rolodex?" I didn't bring him up right. But all those things are under the scope of GDPR. So it's going to extend what your security programs have to take a look at. If you're not already looking at data that's not in electronic form, to comply with GDPR, you want to do that. You want to start expanding your scope. So what is personal data? Personal data is any information related to an identified or identifiable individual. If I say to you, Bob Siegel drives a blue car, I think I'm the only Bob Siegel in the room, so I'm identifiable. And the fact that I drive a blue car is personal information. That's pretty broad. We're not talking about financial information. We're not talking about healthcare information. We're not talking about government IDs. It's just the fact that I drive a blue car is personal information. Actually, I don't drive a blue car. I'm going through my second childhood, so I drive a, what did I call it? Moonwalk gray convertible. Okay. Personal information does not have to be true. It's just information related to an identified or identifiable individual. Think about your performance reviews. I mean, I know they're all perfect, right? But I'm sure there's maybe one or two of us who have disagreed with some of the things that have shown up in performance reviews. Clearly, that's not true. But it's still personal information. Opinions about you are personal information. Now, remember I said identified or identifiable. An email address, generally speaking, is uniquely identifiable. So if I have information about someone, if I have some information related to an email address, that's sufficient to make it identifiable. So but there are other cases where you can say the man in the blue shirt drives a gray convertible. There are enough men in this room that are wearing blue shirts that the individual may not be identifiable. Make sense? Okay. So I was lucky. I grew up in a high school where there were 3 Bob Siegels. And anytime there was a problem, it was the other guy. And now if you Google me, if you just Google Bob Siegel, you'll still get Robert Siegel from NPR. If you Google Bob Siegel privacy, then you'll get me. Yep. So think about the definition of personal information. Think about the information your organization collects about people. And think about what information is protected and what's not. If you have a US-centric based protection program in place, it's generally covering name, first name or initial and last name, plus financial information, health information, and government-issued IDs. Now things are a lot broader. And the challenge this presents for a multinational company is you now have to take people in shared services and explain to them to deprecate what they think about as personal information and think about it from a broader European sense. Yeah?
Okay, so I work for a company. All our customers and suppliers in Europe are companies. But like their contacts that we have, is that contact information personal data?
Yeah, what a great question. So you're in a B2B business, right? And all your customers, therefore, are businesses, but you have contacts within those organizations. The contacts information is personal information as well, okay? Because it's talking about what job they have, what their position is, their email address is personal, their business, the telephone number is personal information, their pictures are personal information. Actually, this part of the law isn't new. It's been around since '95 as well. And it delayed Microsoft from putting up a worldwide address book for the company until they figured out how to get around that type of situation. But you've got to protect that information the same way. Okay? Good question. Okay. So why should you care? Beyond that, there are administrative fines. The most egregious fines under GDPR are will cost a company up to 20 million euros or 4% of their global revenues. Think about that for a minute. Some companies barely scratch out 4, 5, 6% gross profit, net profit. Now 4% of it, 4% of that revenue is going to be taken away. Clearly, these fines are targeted at Google, at Facebook, at Microsoft, the big companies. But the downside of it is it's going to hurt small companies as well. Now, the supervisory authorities, the regulators have the ability to lower those fines, but they can go fairly high. Additionally, there are other sanctions. There could be judicial remedies. They can go to court. 35 minutes after GDPR was in effect, our friend Max Schrems was in court taking Facebook and Google to court for over I think it was $8 million was the total of all the lawsuits that he brought forward. Individuals who are harmed, there can be rights of private action. You could have to pay out to those citizens as well, those residents as well. And then the member states can put further penalties in place, including stopping your doing processing. So if you don't follow GDPR, your operations could stop. In fact, when we chose the chief privacy officer at Staples for Europe, he asked us why did we choose him, and we told him he looked the best in orange. There's also business-to-business customer expectation. If you are doing business with a company that is required to meet GDPR, you will be asked to put in place a data processing agreement. It specifies in GDPR what should be contained in there. But the things that it says, for example, are you can only do processing under the direction of your customer. That you will provide adequate protections of the data, that you will not hire sub-processors unless you get their permission to hire those sub-processors. So it's very extensive, it's very detailed. I'm sure your companies have been getting them already. So when somebody asked me if May 25th was a big day, I said absolutely not. We've been looking at data protection agreements since the beginning of April. GDPR is alive and well. Now, there are 4 roles when we talk about GDPR. The one that most of us think about is the data subject. That's the person whose information we're collecting. So my blue car is a fact of me as a data subject. Data controller is the individual or group who's making decisions about what information should be collected and how it should be processed. The key term here is that they're making decisions. Okay? If I'm running payroll for my company, my employees are data subjects, I'm the data controller. I'm deciding what information gets collected, and I'm deciding how we're going to process it to pay the government taxes and pay them their salaries. A data processor works or processes the data on behalf of the data controller. They don't make decisions about what's happening with the data. They simply process on their behalf. So I have a company up here in Virginia that I work with that does my payroll for me. They are my data processor. When I engage with them, they told me how they did it. I instructed them to use their processes to process my payroll. I'm the controller, they're the processor. They don't do anything else with the data but make sure my employees get paid and the government's happy. The last one is the supervisory authority. Supervisory authority is a regulatory group. Could be a non-governmental group as well in other contexts than Europe, that oversees the processing of data, making sure it's being processed fairly and lawfully. Okay. When GDPR looks at the roles of the data controller and data processor, they look not only at what exactly it says in the contracts, the supervisory authorities will look at the actions that are being taken as well. So let me give you an example. There was a discussion in here about ATMs just a moment ago, and one of the diagrams talked about the organization called SWIFT. SWIFT processes funds transfers from the US to Europe and back. And generally speaking, they're a processor. Bank says, send this money to this other bank or take this money from that other bank, and they do it. But when 9/11 occurred, the US government went to SWIFT and said they wanted copies of all the records of the transactions that took place on that day. SWIFT, without talking to the member banks, gave that information over to the US government. They made a decision at that point about the processing of information, so SWIFT went from being a data processor to being a data controller. Why is that important? Because there are more requirements for reporting. There are more requirements or more potentials for penalties on data controllers than there are on data processors. If possible, you want to be a processor. If you can't, you step up and become a controller as well. We good so far? Okay. So every client I walk into says to me, I've got this security program. It's great, functions really well. Why do I need a privacy program? From a security standpoint, you're all concerned about protecting the confidentiality, integrity, availability, resiliency is also included under GDPR of all of the assets in the company. Privacy is more concerned on personal information. We only focus on personal information. So all of that other data you guys take care of, we don't care about. We want to make sure that we leverage the security function, just like any other business function, to make sure that the information is protected, kept confidential, that it's available, that it's resilient, that it's only accessible to those people who need access to it. We use security to provide the controls that we can't do. So we have to work hand in hand. We're also concerned about what data is being collected, how it's being used, who we're sharing it with, and how it's being destroyed. We want to make sure that data doesn't stay around forever. That son of mine says, personal information ages like milk, not like wine. It gets bad really quickly. And if you keep it around and you lose it, it's only going to cost you. It just adds to your liabilities. We're also concerned with transparency. We want to make sure that the personal information, the data subjects and the regulators know what we're doing within our privacy program. So why is all this important? Because we have certain requirements under GDPR. Let's look at the security requirement, for example. Again, this is Article 32.1 out of GDPR. This is the straight wording. I've added the yellow highlighting because I think it's the most important part. But it shouldn't come as a surprise to anyone in this audience. GDPR is looking for a risk-based program to be put in place when evaluating based on the information that's being collected and the type of processing that's being done. You want to protect the rights and freedoms of the natural persons, of the data subjects. Now that's an important phrase. When we think of privacy here in the US, we think of a consumer function, consumer security function. In the EU, privacy is a natural right. So if we go back to when I talked about who's covered, I go to France and all of a sudden I'm covered. It's because it's a human right to privacy, so they want to be all-encompassing as much as they possibly can. You'll notice also here that it's encouraging pseudonymization and encryption of data. Not every business function needs to have access to all of the personal information. My favorite example is doing marketing analysis. Why do they need to know that Bob Siegel drives a moonwalk gray convertible? They need to know that a man living in Delray Beach, Florida, who is experienced, drives a moonwalk gray car. They don't have to go down to the fact that it's my name. Do they want to know what the other transactions I've done with the company are? Absolutely. So use some sort of tokenization, use some sort of pseudonymization to do that. So the key here is to minimize the amount of data that's being used by people so they can't lose it. 35% of data breaches are because people are trying to do the right thing. They have the data, they're making mistakes. If you don't give them the data, you now cut down by your data breaches by 35%. The other interesting thing here to me is the ability to restore the availability and access to personal data in a timely manner in the event that there is an incident. I talked about destruction of data before. GDPR requires you to identify either the retention periods for pieces of information or the criteria under which personal data will be deleted. Now, if they're trying to get rid of data, that kind of conflicts with the restoration, right? Because we're all using backups to do our initial restoration. So when you have that conflict, when you go to destroy data, delete data, erase data, you don't have to erase it on backups as long as when you restore it, you erase whatever, you roll forward the transactions that got rid of the data as well. And of course, regular testing, assessing, evaluation, so you have to have a compliance program in place as well. Still good? Questions? Yeah.
Are they going to be pushing this down to the supply chain and distribution chain for the smaller vendors have to go through a better management process here to this? Partners or
Yeah, so the question is, are you going to be pushing it down the supply chain? Are you going to be pushing it down to all of your vendors? If you have to be compliant, you need to push it down. If you're giving them personal information, you need to do that. That's done through a data processing agreement. Sub-processors, it's a little bit looser, as long as you're making sure that you're pushing that data, that information down. Now, is everybody doing that today? Absolutely not. I think the last figures I heard, and this goes back about 3 weeks, that less than 60% of the businesses in Europe were ready for GDPR. My conversations with the Irish Data Protection Authority for one of my clients was they're very concerned about how you're managing those sub-processors, right? And if you think about why, think about Facebook, think about Cambridge Analytica. It's the position of the supervisory authorities that that Facebook did not properly oversee Cambridge Analytica as a sub-processor. So that's the first question they're asking companies when they come in to talk to them now. So vendor management's important. Good question, thank you. Okay, let's take a look at some of the other GDPR requirements. Not necessarily security directly responsible, but there are some security aspects to them as well. Transparency is the big one. There's a requirement that you as a data controller are transparent to your data subjects. As a data processor, you need to be transparent to your controllers and let the controller be transparent beyond that. So some of the things you want to have is a privacy notice. There's specific information that's required to be placed in a privacy notice. The name of the data controller, information that's being collected, why it's being collected, how it's being processed, who it's being shared with, how it's being protected, if it's being transferred over national borders. And if it is being transferred over national borders, how is it legally allowed to do that? And by the way, what's your legal basis for processing the information? Before May 25th, the most popular way to process information was based on consent. But consent got much harder to do under GDPR. It has to be freely given, it has to be by an affirmative action, and it has to clearly express the wishes of the data subject. And it has to be specific. So just having someone agree to your terms and conditions is not sufficient. You need to get them to agree to specific things within your processing program. Also, remember, if you're asking for consent, consent can always be withdrawn. So if you're basing your processing on consent and somebody says stop, you have to stop your processing. There are 5 other legal bases. The ones that are most important for non-governmental agencies would be under contract. I'm buying a shredder, so I have to process the information to sell you the shredder. Or legitimate interests of the business. Direct marketing is considered a legitimate interest of the business, as is fraud protection. So if you're collecting personal information to protect your infrastructure, that's okay. Just remember that what you're putting in the privacy notice are enforceable promises. Even here in the United States, if you're making a statement in your notice, you have to do what you say. Otherwise, From a US perspective, the FTC will be after you. In the case of Europe, it'll be one of the supervisory authorities. There is also things called data subjects' rights. These are things that have been told to the data subjects that they have the right to do with data that you have about them. They have the right to access the information that you have about them. They have the right to rectify the information you have. They think you have a mistake in the data, they have the right to ask you to change it. You don't necessarily have to change it, but you want to review it at least to see if it makes some sense to do. And by the way, for right to access, you want to authenticate that this person is really who they say they are. That's probably something that your call centers haven't really done very well before, so you may want to put some new processes in place there. There's this right to data portability. Information that you've collected from data subjects by contract or consent that are in electronic form have to be provided to them in electronic form at their request, in a form that can be given to another business, potentially a competitor. The source behind this, I wanted to move from Facebook to Google+. I need a format to be able to do that. There's the right to erasure. I don't believe I'm doing business with you anymore. I don't believe you need my data anymore. I want you to erase all the data you have about me. And unless you have a good business reason or a legal reason to say no, you have to do it. Which begs the question, are all your systems that contain client information, customer information, linked with a single identifier to make it easy to erase all the data of an individual with one transaction? I would bet against it. I have one client who has 3 people employed just to do that because they don't want to implement the technology yet. The difference between erasure and the right to be forgotten is the right to be forgotten is telling other data controllers that your data subject has asked that the information that you have on them has been erased and they want it to be forgotten by anyone else you shared it with. So if you shared it with Google, if they were able to go through your site and pick up information. If you shared it with an industry group, they need to forget it as well. They have, data subjects have the right to ask you to restrict processing. They don't believe you have a legal basis for doing it. They don't believe that you should be doing this processing. They could say to you, keep the information, but don't erase it until we get this discrepancy resolved. If there's a legal action going on, that may be a reason that they would want to just restrict processing. There's a right to object to processing, which is, I stop my processing and erase it when you can't prove to me I'm doing it right. And there's also a right to object to profiling and decisions made by automated processing. So if somebody comes in, they put in a credit card application or loan application, they get a very high interest rate based on the automated processing, they have the right to ask for human intervention. Okay. They also have to remind them within the privacy notice that they have the right to complain to a supervisory authority. So you got to tell them if you don't like what I'm doing for you, go tell the supervisory authority. The other new thing under GDPR is breach notification. We never had to do this in Europe. Here in the US, we have to do breach notification on a state-by-state basis. Generally, you have to notify the data subjects without undue delay. It's a little different in the EU. Data processors need to notify the controllers without undue delay as soon as they become aware of the breach. Not confirmed of the breach, but aware of the breach. That fulfills the processor's obligation. The controller needs to then notify the supervisory authority, like the Irish Data Protection Authority, for example, within 72 hours, but within undue delay, only if there's a risk to the rights and freedoms of the individual. So let's say there's a data processor loses your customers' names and addresses. They have to notify you. But based on the loss of names and addresses, you need to make a decision whether or not you think there's a risk to the data subjects, and if there isn't, you don't even have to notify the supervisory authorities. After you notify the supervisory authorities, you're going to tell them whether or not you're going to notify the data subjects. The data subjects only need to be notified if there's a high risk to the individuals. And again, high risk isn't defined. Losing name and address, I would suggest, was probably not a high risk. Okay? There are exceptions. If the data has been encrypted or it's unintelligible, it's been obfuscated, same as here in the US. If you lose the keys to that encryption, then you have to notify too. If you've taken actions after the breach to reduce the risk, you may not have to notify. Or if it's going to cost you a fortune to notify the data subjects. That's the disproportionate effort. If it is, you can use alternate means, emails, go through media, post things in newspapers, radio, things like that. With an application development, there are changes there too. From an application development standpoint, there is a concept originally known as privacy by design that has been moved to become data protection by design. The philosophy is that every requirement from privacy should be treated the same way as any other business requirement. Privacy should have a seat at the table. GDPR is requiring that this happen. Okay? They are also, and by doing that, you start to use pseudonymization, data minimization. You get all the basic principles associated with privacy involved with the implementation of a new application. This has an impact on security, right? Because now you guys are going to have to work with the application development teams a little bit earlier on to define what safeguards need to be put in place to make sure the privacy requirements are met, data protection requirements are met. There's also protection by default. This is an aspect of privacy by design. Basically, it says that from the time you collect the personal information to the time you delete the personal information, it should be protected. That there shouldn't have to be any actions taken by the data subject to protect their information. I shouldn't have to go onto my Facebook page and set my privacy settings. They should be set for me. Okay? So now there may be some consulting you want to do with your application teams about what controls should be put in place and how to turn them on and off to give the data subject the best privacy possible. And there's a concept of data protection impact assessments. Basically, anytime an application is being changed or a business process is being changed that is applying a new use of personal information or collecting new personal information, you're reviewing it to make sure it stays consistent with your policies and stays consistent with the legal requirements as well. If there's a high risk to the data subjects after the assessment is done, you bring it to the supervisory authorities and ask them to consult with you to figure out how to resolve it. So they're trying to be cooperative. They're trying to prevent bad things from happening up front until after things are deployed. Yep. So who is going to, one other thing before I forget. We started talking about vendor management a little bit earlier. There's a lot behind vendor management. You're going to put a data protection agreement in place. They have to have adequate security. They can only engage sub-processors. You can only engage a sub-processor when they say it's okay to do. You're only going to process information based on instructions from the data controller. Otherwise, you become a data controller, not a situation that you want to be in. You want to assure that your employees are committed to confidentiality and security. Make sure the training's in place, that testing is in place, the fact that's already done, so that they know what's going on. If there are access requests, any of those data subjects' rights requests that are coming from data subjects, they're not going to come to you as a processor. They should go to the controller, and you need to provide the supporting functionality to the controller. And then assisting the data controller responding to supervisory authorities in case there's a breach. When the contract's done, returning all the data or deleting all the data, something that gets forgotten about all the time. And you need to demonstrate compliance with GDPR. Have an assessment done or an audit done. Now, the other concern is data exports. The European Union wants to make sure that any data of their residents that is going to another country is adequately protected. There are about 13 different countries, roughly, that have been reviewed, their laws have been reviewed, and have been determined to have adequate protections. The United States is not one of those countries. So instead, we have this program called Privacy Shield, where you can voluntarily, if you're overseen by the FTC, register for Privacy Shield and say you meet certain requirements. It's done on an annual basis. It's a 3-month or so process for you to review what you're doing internally and then compare that to what the requirements are, and finally attest to the fact that you're Privacy Shield compliant and to register. If you don't want to go through that process, there are ways that you can show that you have adequate safeguards. For example, there are some standard contractual clauses that you can find on the EU's website. If you fill in the blanks, this is the data we're transferring, this is the purpose that we're doing it, this is the controls that are in place, and this is where it's going, leave all the other wording alone, you're fine. The supervisory authorities will accept that. On the other hand, if you write your own contractual clauses, they're going to take the time to review them. And security is obviously part of those clauses. There are approved codes of conduct that are included in GDPR. They're looking for third parties, for industry to create those codes of conduct and certification mechanisms. To date, and it's only been a week, none have been approved yet. There are some international agreements, particularly for law enforcement. The last one, binding corporate rules, is where they want you to go. Binding corporate rules is establishing a set of data protection requirements that apply throughout your enterprise all over the world that you would adhere to. They get approved by the supervisory authorities, and then you can transfer data from the EU to any place in your organization anywhere in the world. It's a very brief summary of it, but that's where they want to go. The fastest I've seen binding corporate rules put in place is 6 months. That was for Corning Glass. There are other derogations. Derogations are, think of them as one-offs. You can transfer data by consent, but again, consent can get revoked. So you want to try to stay away from that. You can do it in performance of a contract. Again, but here you're talking about one-off things. So for example, you now have a new vendor or new customer you're dealing with in the EU. You want to get the contact information from their people over into your databases so you can do business together. You can do that under a derogation, and so on. Just a number of different things here that you can do. But the ones on your left are the ones that you want to pay attention to for things that are repetitive transfers of data. There is a new role that's been established, the Data Protection Officer. Now, you may think that the Data Protection Officer is here as a security role or as a privacy role or some combination of the two, who has oversight and is going to go and make everything right and GDPR compliant. Not really. What the DPO does is they ensure that they can demonstrate compliance for your organization with GDPR. Doesn't say they have responsibility for it. It just shows that they can show that compliance. They can provide advice to the organization about how to become GDPR compliant, how to protect data. It's up to the organization, though, to make the choices about whether to accept that advice. Okay? So the DPO is kind of like a consultant. You should do this. No, we don't want to do this. Okay, I documented you should do it. I'm okay. They need to be an expert in data protection law and data processing techniques and data security. It could be somebody within the organization, could be somebody from the outside. I serve as DPO for several organizations. It can be somebody internally that does it part-time, as long as the role doesn't conflict, the role of DPO doesn't conflict with their real job. The VP of marketing is probably a bad choice for a DPO. Okay. But some of their tasks and responsibilities, they're monitoring compliance, they're advising controllers and processes about what the right thing to do is, they're helping manage risk, they're identifying the risk and saying what needs to be tackled. They're cooperating with the supervisory authority, and they're providing communications channels as well. Think of the data protection officer as wearing two hats. When they're talking to customers, data subjects, when they're talking to supervisory authorities, they're wearing the company's hat. But when they're working within the company, they're wearing the supervisory authority's hat. And the nice thing about being a DPO is if you're doing your job and you're making recommendations, even if the company doesn't like them, you can't get fired. You cannot get fired for doing your job as a DPO. It's written into the law. Okay. Oh, and every company does not need a DPO. You need to be doing a significant amount of processing, large amount of processing, or processing what's called special categories of data, things that people might get discriminated against or were discriminated against during World War II is the best way to think about that. If you don't need a data protection officer, do not nominate a data protection officer. Give someone their responsibilities, but give them a different title. As soon as you name someone a data protection officer, all the responsibilities of GDPR fall down on you. Yeah? No? That's your question. Okay. Yes? If it's in the public interest. So think about the Tylenol scare that we had years ago where Tylenol was tainted on the shelves. Or think about a terrorist that's coming to the U.S. Those types of things. So it's in the public interest to get it out. And those are extreme cases, I know, but they're just two easy examples. Okay, so what should you do now? We're post GDPR day. We're living in a post GDPR era. Figure out if you're in scope. If you have facilities in the EU, chances are you're in scope. If you're selling goods and services into the EU, bless you, you're in scope. Do you monitor the activities of EU residents? Is your website translated into different languages? Do you accept addresses and phone numbers that are in European formats? So you're welcoming European data subjects into your website. Chances are you're in scope. And do you keep information about residents of the EU? If you are in scope, assess practices against GDPR. This is what I'm supposed to say. If you need help with that, I can do that. Create a plan to address any gaps you find, and then stay on top of any new processing or legal requirements that come up. GDPR opinions are new. Up until now, we've been guessing to a large extent about what it meant to be GDPR ready. Now the rubber meets the road. We'll find out what's really going on. Any questions? Yes. Yep. So if you have a facility in Europe, or right. So yeah, I will. I'm trying to understand it before I could repeat it. So, so if I have a server, if my data is in the cloud and it resides in Europe, do I have to be GDPR compliant? The data processor, because they're operating in Europe, has to be compliant, which by extension makes you have to be GDPR compliant as well. Yeah.
If your data is already pseudonymized, essentially the deletion or erasure wouldn't count if they ask you because you wouldn't be able to identify the person anyway. Is that correct?
Great example. Great question. Great question. You get a request to be erased. Do you have to actually delete the data? If it's pseudonymized, chances are that the identity that the token relates to is in some table somewhere. Just to erase the personal information associated with that token, and you've now made it non-personal information, so therefore GDPR doesn't apply. If you're not using pseudonymization, just delete the identifying information. And it becomes information you can still use, but it's not personal because you can't relate it to an identified or identifiable person. Great question. Thank you for asking. Yeah.
So if you're not directly selling, offering goods and services to EU residents, but your website is accessible in the EU, and your website tracks IP addresses, which I've heard is in some cases, some instances considered as personally identifiable, are you, do you then have to comply with GDPR?
Good question. So the question was, you're not selling goods and services to Europe, but people do come to visit your website. You are using Google Analytics or Omniture or someone to track clicks or some other package to track who's come to your website. You have IP address, which the European Court of Justice has found that in some cases is personal information. Do you have to be GDPR compliant? No, let me rephrase that. It depends. It depends on how your website is set up. If you're saying in your terms and conditions or in your privacy policy that this is meant for citizens of the US, you should be fine. But again, if the European Union looks at it and says, and I doubt they will on a small scale, but if they look at it and say, no, you really are collecting this information from European citizens actively, then you would have to. But from what little you're telling me, it sounds like you should be okay and not have to comply. We can talk more if you'd like. Any other questions? Yes?
Has there been any thought about customer service on erasure? Like if you have a customer that has transactions, like purchase things from you, request erasure, then if it comes up later like, oh, can you resend me a receipt or can you refund my transaction? They're now not able to do that because you can't really have a record of their request for erasure.
Right. It's a good question. I had this conversation just yesterday with one of my clients. There are financial legal requirements to keep records for a certain amount of time. If you are legally required to keep information for a certain amount of time and there's a request for erasure, you don't have to honor that request, explaining why you're not. But on the other hand, let's say that legal requirement isn't there and they ask you to erase. Keep a record that on such and such a date, Bob Siegel asked you to erase the data. Here's the email we sent back to him saying that we complied with it. And then when I come back to you and say, I need a receipt from January 15th, you could say, no, you requested the data was erased, and here's a copy of the email we sent you confirming that. Okay. Yes?
What do you recommend as a best practice for evildoers who may say, I want to go and protect your data deleted from some, say, for example, like a hiring site or something. What do you feel is best practice to make sure that requests are genuine?
Yeah, so the two aspects to that question. The question is, what happens if somebody else asks to have your data deleted? Let's say, for example, I went to a company and said, I want my ex-wife's data deleted, right? You need to have some sort of authentication process for that. I always recommend using something that only you and that data subject know. The value of the last transaction, the last date of purchase, the last product that was purchased, something that only the two of you would know. With all the security talent in the room, I'm sure there are other alternatives that are better. The other thing to be aware of, when it comes to erasure, there may be situations where erasing the data may infringe on the rights of others. If you sell somebody a product and ship it to a third party as a gift, and that third party says, erase all my data, you can't erase the information for that first party who made the purchase. You should be infringing on their rights and freedoms. You say you have the right to that information too. I'll be around here for a little while. Be happy to talk, happy to give you business cards if you want to follow up. Thank you for participating. I hope you found it educational.